In this lecture, we will look at the sources of law. There are four primary institutions that provide us with laws of the country. Parliament and courts are the national institutions, and European Union and European Court of Human Rights are community institutions influencing national institutions. The Parliament produces legislation in the form of statute law, which in UK are the highest form of laws. This can be contrasted with the US that has a constitutional document, which supersedes statutes either enacted by the Congress or state legislatures. The statutes are not only inherently complex as they are open to interpretation, they are also becoming more and more difficult to understand due to the rise of modern economies. The Parliament also uses parent statutes to delegate the lawmaking power to ministers and other bodies and to facilitate the executive work. However, this poses some serious concerns because the secondary lawmaking power is not regulated or scrutinized on the same level as the primary legislative powers of the Parliament. However, there is an ultra vires rule that allows judges to intervene if the ministers have gone too far with the power given to them. Another interesting fact about the Parliament is that a Parliament cannot restrict the legislative power of a future Parliament. Applying these statutes and powers to practical matters requires interpretation that can lead to different meanings of these statutes. This is where the courts come into play. The courts provide us with the correct interpretation of the statute. Another reason courts are a source of law because they have been developing law through common law tradition. This tradition has its unique features like precedent, case reports, and case judgments. The most important thing to know about the court structure is that the highest court in the UK is the Supreme Court, which was formerly known as House of Lords. A case can be brought to the criminal court if a person has committed a crime against the state, or a civil court if the dispute is between two individuals, for example, in a contract. It is important to mention Wolf reforms here, because they have improved the working of the civil courts by expediting the process through case management and by giving the parties an opportunity to resolve their issues before they reach the court. This process is known as ADR, or Alternative Dispute Resolution. The third source is the European Union. UK joined the European Union in 1973. European law and its principles have mingled so much with UK law that now if you are looking for a qualifying law degree from UK, it is mandatory that you take EU law as part of your coursework. So it is very important to know about the EU legislation and its effect on the English legal system. Treaties are the main source of EU legislation and are called primary legislations. In the British constitutional arrangement, a treaty is only recognized in the national system if it was incorporated by an Act of Parliament. EU's influence on the English legal system can be realized by the fact that European Communities Act was passed back in 1972. The Act gives effect to the EU's primary and secondary legislation in UK. Through this Act, the Parliament has given up some of its sovereignty. It's important to remember that future parliaments are not bound and can repeal this or any other act by an ordinary procedure. The Factor Thami cases have established that where there is a conflict between community law and national law, the courts can disapply an Act of Parliament. The fourth and final source of law is the European Court of Human Rights, which is part of the European Council. One important thing to remember here is that European Council is not part of the European Union. The European Council and the European Conventions on Human Rights were developed in the aftermath of the Second World War to provide protection to rights separately from the European Union. The Labour Party introduced the Convention rights into UK by passing the Human Rights Act of 1998. Let's look at some of the norms and values of law and how they apply. First, we will look at the legal traditions and then we will look at the internal, predominant Western traditions of law, common law and civil law. The common law system represents the legal system of UK, US, and Commonwealth countries, both former and current. The tradition coexists with the civil legal system like in Canada and with religious legal system like in Pakistan. It is also interesting to note that the majority of the countries in Europe and European Union are civil law countries. Ireland and UK are the only two common law countries in EU. The common law system is adversarial in nature, whereas the civil law tradition is more inquisitorial. What this means is that in a common law court, the two parties fight for their case, whereas in the civil court system, the focus is on finding the facts of the case. The civil law tradition focuses a lot on the codification of law. The codified laws of the European Union has heavily influenced the common law tradition in UK. One example of this influence can be seen by the codification of rights through the Human Rights Act. On the other hand, the common law tradition follows precedent with less emphasis on codification of law. Because of the huge influence of EU law on UK, which is codified and civil in nature, we will be discussing these influences in future lectures. The common law tradition can be further classified between criminal law and civil law. They both have different functions and aims. The criminal law aims at punishing the wrongdoer, while the civil law provides redress for the victim who has suffered a wrong by another individual or a company. Criminal law is punitive in nature, while civil law is remedial in nature.